So today's lecture is right to privacy and right to information. Very important discussion and very important aspect of right issue. Uh, okay. So first I'll discuss about this privacy, origin of privacy, which is important, and how we'll define information privacy and importance of privacy is very important. So we see that when you talk about this privacy, when it is originated uh, from the Latin word called privatus. Privatus means uh, that secluded from the race, that is to be secluded from the rest. That's how we understand privacy. And when we say information privacy is a bit different from the whole concept of privacy, because when we understand privacy, it is a very broader concept. It involves privacy in person, privacy in behavior, which I'll be going to discuss with you, as well as privacy in personal communications. And now in the digital era, we are talking more about data privacy. So information privacy is also related to data privacy. So your control over the information, your choice how information is being used, for what purpose the information is used, when it is being collected, how it is being collected. So information privacy refers to the choice of the individual or the data subject whose information is being collected, and control over choice and control over the information of the data subject themselves. So when we talk about the privacy is basically that willingness to seclude it from the rest, and this is also recognized as the part of right to liberty. But the Indian Constitution has given a verdict in 2007 and made privacy a fundamental right. In 2017, we actually get right to privacy as a fundamental right. But prior to it, we also see that we have Universal Declaration of Human Rights recognized right to privacy as a very important human rights. So we see those dimension of privacy. So you talk about the privacy of person first. So when you talk about the privacy of person, it is all about how you conduct yourself in a public domain. So it is your privacy, your conduct, your behavior, your attitude, your communication, your interaction with others, your disposition. That's what is privacy of person. Then privacy of personal behavior and privacy of personal communication. These are two different aspects. When you talk about the personal behavior, this is about your behavior in public domain, that may be online and offline space. So among people, how you behave as a private person, you behave as a public person, your dispositions, so your interest to be secluded from the rest. Okay, your attitude towards the information which people can access, which people can dispose, whether people can access it or not, and your control over that information is basically personal privacy. And when you talk about the personal communication related privacy, this is more about verbal and non-verbal communication of privacy. Even when we see that a private person can project themselves through non-verbal means, the way he communicate that I want it not to get disclosed or so. Even through non-verbal communication, we get a lot of cues about a private being. We talk about a private being, so solitary being, or want to live a solitary life or secluded from the rest, and that is entirely his or her life. But at the same time, we also need to give regard to that personal space, is a personal communication, we see. And that at times we get to find from the very behavior of that person and also disposition of the person. So this concept are relatable a bit. So when you talk about personal privacy of person, personal behavior, personal disposition, and also about privacy of data. So communication, personal communication is different from personal behavior, because behavior is about the code of conduct that you follow in public domain, and communication is about your verbal and non-verbal communication, some cues you provide to others while communicating. what are being disclosed and what you are disclosing. Okay, then you talk about the privacy of personal data. It is basically data are being circulated, right, in online world. Now you see with the advent of ICT, lot of data have been circulated across the world. Your control over the data is very important, paramount importance. So that is what we try to define as privacy of personal data. So our control over the data, and when there are different surveillance tools and technologies used by private industries and government bodies to create a surveillance upon us, and surveillance upon us in order to uh, create a better future. But because when you talk about the surveillance, there is also a purpose inherent in it. I'm going to discuss about the importance of data privacy and how it is related to data surveillance. And before that, we also need to look at that privacy and confidentiality are two different things. So when you talk about the privacy, it is the privacy of the matter, you want to keep it private and secret. And when you talk about confidentiality, this is some information, confidential information, which is not to be disclosed. But when you say privacy, that information can be disclosed also, you may not have control. It is about your control over the information. You lose the control, so information is being disclosed. But when you talk about confidential, this is something which is very classified, and it is to be kept secret. Okay, information is not to be disclosed. So that is the distinction between privacy and, you see, confidentiality. Then we have these three aspects of privacy. We see the spatial privacy or physical privacy. The privacy around your space is spatial privacy. Around your space, you see the online and offline space. When you talk about the online space, maybe social networking space, social media, often we use, and also different kind of email, and also digital technologies, different digital tools that we use, and privacy related to that space, that special space. And when we talk about the physical space, when you were also busy in a meeting, you were in the midst of your friend, and the kind of privacy that you hold basically refers to the spatial privacy and physical privacy. So here we talk about the physical space. Physical space is supposed to be unhindered by any uninterrupted calls. So we don't expect a telemarketing calls at times. So because at times we feel that our that presence in that very situation got disturbed. So that is basically a physical space. We say that we want space. So we want that space so that we can grow. Right, we want that space so that certain informations are not circulated, and which might also you say impact the identity of that person. Also you see that may be disregarding the overall identity of that person. So choice is the personal capacity to make you see certain, it is about personal capacity to make certain choice without intrusion or interference. So whenever you go online, whenever you use any online medium, so then the kind of choice that you actually exercise regarding you giving information to anyone, and whether that choice is subject to intrusion or interference or not, that is important. And then information privacy, what we have already discussed about your control over the privacy. So you see, when you talk about information privacy, it is connected to data privacy basically, and data privacy comprises these four steps. We talk about data collections. How data is collected is important. So here we have body corporate. There is also one aspect of it. Body corporates are there, those companies, the private companies, even the government. Now government will not be included in the body corporate, but body corporates are basically the private companies, and intermediaries, the third party, they usually get access to our data. And even if you actually see in general sense how information is being collected You see, when information is being collected, there has to have a purpose. So, data collection refers to the very purpose of the collection of the data. Why that information is being collected, when that information is being collected, and how long that information is to be retained is very important. Then data security and data storage is very important. So here when you talk about the security, whereas any safeguarding mechanism, any kind of security mechanism in place to secure this data, to keep that data in safe custody or not. So any kind of data, any information suppose you hold, that has to be updated. So unless it is updated, you cannot even guarantee the security and storage of that information. So when we talk about data security, basically we are talking about a security mechanism in place and also frequent updation of that information. Then we talk about data process. Data process is how data is being processed. That basically refers to the retention policy. You see, the retention policy, how long this data will be retained and when this data will be deleted. So when data is being processed, when data will be deleted, and that is also under the control of the data subject and the intermediaries or the body corporate, and when the data is, how long this data will be retained. And then we have data access. When you talk about the data access is basically giving access to your information to someone. That is what data access. So all this data privacy is also related to information privacy because it refers to the very control and choice of individual over the information that he gives to other, that they give to other, and also uh, uh, if he or she wishes, those information could also be, you see, can deleted, could also be corrected. Okay, so, and this is equivalent to even data privacy. For what purpose the information is collected is being emphasized upon data collection and information collection. Then in data security, emphasis is more upon the security mechanism and updation of this data. In data process, importance is given to the retention policy, how long it will be retained, and in data access, information is given to control over who can access to that data, and also if necessary, if that data can be deleted, it could be corrected or not. Then you see the right to privacy, there are certain issues, certain laws are also involved. You see certain laws like Article 21 of Indian Constitution, that is the very fundamental law of the land that guarantees right to privacy. Apart from it, we have also Indian Contract Act, Indian Telegraph Act, then Consumer Protection Act, Indian Copyright Act, Indian Penal Code, IT Act, usually deal with data privacy and privacy, not data privacy, privacy. So right to privacy, as I have already told you, it is recognized as a fundamental right under Part 3 of Indian Constitution and after 2017, and right to privacy is also being recognized as a human rights by United Nations organization under Article 12 of 1948, that is Universal Declaration of Human Rights. Now you see that privacy of children is very very important here. So I'll be discussing about privacy of children, women and minority a bit, and it will be followed by a tutorial later on. And then some new kinds of cybercrime have arisen. You see, voyeurism, electronic voyeurism is there, phishing attack, and when computer is used as a tool, computer is used as a target. So there are different kind of cyber crimes have come into place, and most of the cyber crimes have also intruded into the private life of the individual. And hence, so when you talk about those very annoyances kind of crimes, we cannot even deter ourselves but to discuss about the cyber law. Cyber law is one law that actually covers the whole cyberspace, and we actually see that it deals with the electronic and digital signature, intellectual property, data protection, and crime. And cyber law deals with all variety of, you see, cybercrime. So when you talk about the variety of cybercrime, you have also seen it was a virus attack. Then we have DOS, okay, that contamination of the system, then destruction of the system at the same time. So you have different way get to see how your computer a passcode or security code is being broken down and also bypass the security and get access to the computer. And so different variety of cyber crimes are there, and cyber law provides the protection against those cyber crime. So we actually have some dimensions and aspect of cyber laws. It deals with the electronic and digital signatures. So that basically refers to the signer authentication and message authentication in the digital world, and the message integrity in the digital world. So any electronic signature which will also keep the electronic record safe. Then we talk about the intellectual property, that is also another aspect of cyber law. Then data protection and data privacy. This is very important aspect of cyber law, which we will be discussing more. And here I am giving some references. You simply look into it. So there are some primary sources of, you see, we have mentioned about IT Act. IT Act rule. IT Act was passed in 2000, and then IT Act rule that came in 2011. Both are very important in terms of understanding the protection to right to privacy. Then we have also other order related to blocking of the website, that is also an act of surveillance on government. Then we talk about digital evidence, which is to be collected and proven in the court as per the provision of Indian Evidence Act. So Indian Evidence Act is there, which is also amended by IT Act, and according to which digital evidence can be collected and can be proven in the court. And then in the bank record, we also see there is a provision of Bankers Book Evidence Act, which is also amended by RT Act. These are relevant. So why these are relevant? Because we also see that when you talk about the financial information, which is a sensitive information, so it's very important privacy document, and the kind of uh, that safety measures which are being taken to even keep that record safe is very important. Okay, and hence we have certain laws which are important to understand even for journalists also. And then we see that we have national privacy principle policies. When we talk about the surveillance will also go in hand with the privacy, right to privacy. Right to privacy is being recognized, and meanwhile government has also, you say, spread the surveillance mechanism. So when we talk about the surveillance mechanism of government, one is Aadhaar. So different way government have been collecting data from us, right? And data are usually stored in these databases, and many times these databases are also used for micro targeting, for behavioral advertising, micro targeting of the population during the election time on the basis of the demographic, their age, their interest, their income level, which are also procured from the electricity bill and different bill items where we can provide our personal information. So those information could also be classified as personal information, demographic informations, which are being used during micro targeting during election by this government. But that is also a part of government surveillance mechanism. So government usually collect this data, even through Aadhaar also government is collecting data, and there are also different tools through which data from individuals are being collected. Like you see this, we call we have biometric tools are there, face recognitions, then voice recognition, iris recognition tool, then radio frequency identifiers, then also we have a voice over protocol. So like that way we have different tools and technologies through which data are being collected. And now data has raised a very important issue. Now you see, we also have body corporate, like Google is also one body corporate. And there are third party, those are intermediary. Intermediary are also there, third party, and Google can also take information from us and are also sharing those information to third parties. And privacy concern has raised a very important issue in that case, how those information are being handled by body corporate. And we have also certain uh, section incorporated in IT Act to deal with that privacy issues related to body corporate and intermediaries. Now you see the national privacy principle, as I have told you, that government has already spreaded that surveillance, but this surveillance is not you say unfair, because government has also gone through a process of making a legal framework of it. And the you also see that planning commission now, we have got a rename of it, Niti Aayog Planning Commission. I had a meeting earlier with a group of experts which is chaired by APSA. APSA was the chief justice of Delhi High Court, and that SAR report have pondered upon these very principles. They have worked on these very principles. One is the principle of notice. Notice is very important related to privacy. It is about notifying the data subject. So here, when we discuss about these principles, it basically emphasized upon the relationship between the data subject and this data which are being taken, data which are being procured, and the data subject. We are the data subject, we individual which are giving data to the body corporate, to even the applications, online applications, and different software companies and different private companies, and to government. We are giving the data and we are the data subject. Okay, so the relation between that data holder and data collector, data subject, and that data processing, the information which is being given, that is a kind of interplay of these three concerns are being dealt with by national privacy principle. So we actually see the principle of notice basically talking about noticing, notifying. Notice in the sense giving a notice or notifying the data subject about the collection of this data, and what is being collected, why it is being collected, when it is being collected. So it is very important, right, to notify the data subject that data is being collected, when it is being collected, why the data is being collected. Okay, and so that they could also get the informed consent of the data collector. And then we have principle of choice and the consent. It is basically to uh, give the data subject some choice over correcting the information and also deleting the information. So without the consent of the data subject, data collector cannot share the data with intermediaries and third party. It is mentioned in the privacy principle that data collector is supposed to give the choice and take the consent from the data subject. Then principle of collection limitation, it basically refers to limitation of the data which are being collected. So whatever data is being collected, those data is supposed to be adequate and relevant to the purpose for which it is being collected. So otherwise, if you actually collect an enormous amount of data, or you see that redundant of data which is not even relevant to the very purpose, it will actually lead to a kind of Orwellian state. Okay, and you also talk about the principle of collection limitation of the data. So only the relevant and adequate data are being collected and should be collected. Then you see the principle of purpose limitation is very important to identify the purpose, and on the basis of the purpose you collect this data and accordingly you notify. Okay, then you talk about principle of excess and corrections. So there are some overlapping of those very principle. So you actually give access of the data to the third party after getting informed consent from the data subject. and also let data subject correct whenever they wish to correct the data and update the data. And then we talk about the principle of disclosure of information. So information is there for disclosure. Even every time we use an application also, you see there is an aspect called data automation. They usually take the information from us, they analyze the information, they also implement their analysis, then they disclose the information. I'll give you one example regarding this data automation. Like we have used this last FM. Suppose we use any applications, they usually take information about the song we prefer, the singer we prefer even, and which film we prefer. And they collect the information, they sense it without even having any control over us. So without having our control over the data, they take the information from us about the data, about that information, about the song we prefer, about the film which from which that song is being copied. Okay, and then they circulate that information across the social media. So they disclose it ultimately. So you see that is the principle of disclosure, and disclosure is also have different purpose. And for body corporate, you see body corporate purpose is marketing oriented, so they are driven by the profit. Okay, so disclosure of information, they can disclose the information once they get permission and consent from the data subject. And principle of security, it is very important, that is also related to those data I have already told you. So a proper restriction and reasonable restriction and security mechanism has to be placed so that you see that whatever being collected are secured. Okay, and principle of openness is very important. Openness is also related to the procedure of collecting data and the whole procedure, how you are collecting the data, and that is in compliance with the uh, uh, you see in compliance with the whole process of data collection. So the procedure, the way you have collected data, that should not minimize someone's uh, understanding about the, like, data generations or data collection, in the sense that when I'm giving data, so I'm also open to the, I know the way they have collected, and why I am giving that consent. So that is basically the openness of the privacy principle. And that principle of accountability, that data is supposed to be disclosed, but if that person doesn't want the data to be disclosed, data subject, it is not to be disclosed. So we talk about, and the greater accountability is there. It is also government to, when they hold this data, they procure data from us, they definitely they are accountable how they use those data. It's very, very important. And there is also, you see, purpose limitation and collection limitation involved. Purpose limitation and collection limitation. So we also see that is Electronic Frontier Foundation Privacy International Action and Access. They drafted International Principle on Application of Human Rights to Communication Surveillance. Now you see how privacy is related to surveillance. It is also important. So we will move to the next slide. Okay. Prior to it, mm, okay. Uh, So when you talk about surveillance, surveillance has a different reference altogether from privacy. So when, okay, because this is different basically. It is talking about the children privacy online. So we talk about this surveillance. Surveillance mechanism is connected to privacy at the same time, and at times government come up with different surveillance mechanism. Government, you say, in online, government can even block the internet service providers, they can block service providers, and in China autocratic regime, usually exercise lot of surveillance over the citizens on the use of information. So basically, this is also a way to restrict the freedom of movement, freedom of opinion, freedom of press and expression. So you see that when you talk about this government surveillance, it is also important to understand some of the tools. Like we see the content filtering is there, and content catching tool is there. So it is true which some of the content which are sensitive are being caught by government, and also stop from being disclosed. And also you see content filtering filter some of the content which are deemed to be very sensitive. So that is also a part of surveillance mechanism, and whenever there is a surveillance in place, there are also certain clause that a government need to satisfy. So you see in India, even in other countries also, these very clauses are similar, familiar and similar. You see, we used to transmit information, and we use not to transmit information which will actually divulge the state secret. We will not to transmit certain information which will also lead to harm the national integrity and sovereignty of the country. We will not to transmit certain information which will also not lead to defamation of an innocent person. We will not to transmit information which will also lead to public disorder. So these are the very clause which we need to satisfy and follow in terms of uh, uh, surveillance. Not we, the government usually follows in terms of surveillance. So we see here, when we discuss about the IT Act, we also have an IT Act, Information Technology Act, and we have Information Technology Rule. Information Technology Act was passed in 2000, and Information Technology Rule came in 2011. And both this you say act and also rule provided a provision to protect the right to privacy. So, and it has also given the government power to issue direction for interception. You see, at the same time, when government can intercept our call, suppose public body, the state can intercept our call, so that is entirely on the surveillance basis. So government exercise surveillance and intercepting the call. So government, especially the Home Ministry and Home Department of the state government, has the right to exercise surveillance, and they can also issue direction regarding intercepting of the call. Apart from that, we have also National Human Rights Commission, then Central Bureau of Investigation, CBI can also go for intercepting requests for blocking of certain website, or intercepting, not intercepting the call, they put up a request for blocking of certain website. But that the joint secretary of you see Home Department, Ministry of Home Department in state government and central government can issue direction regarding intercepting of the call if they found any doubtful. And IT Act, there is also provision, section 69 of the IT Act actually dealing with the power of issue direction for interception or monitoring or deprivation of any information through any computer resources. Then we have rule 419A, 419A or 419A, that was added to Indian Telegraph Rule 1951 under the Indian Telegraph Act, that has provided who can access the order on interception of communication. Then, as I have already told you, that government need to satisfy certain clause, and if it is necessary or expedient to do so in the interest of the sovereignty and integrity of India, defense of India, security of the state, friendly relation with the foreign state, public order, preventing incitement to the commission of any cognizable offences relating to the above, and investigation of any offence. So here we actually get to see these are the clauses which are similar almost all the regime across the world, not only in India. In China also, when we talk about the blanket surveillance, we have certain example in China, like China adopted that Gold Seal software project through which try to catch the content, sensitive content of users. And also there is a Green Dam project that is another project, that's a software which Chinese government came up with a private body and invested lakhs of rupees to even make this software and pre-install this software with the you see technology. Okay, in order to find the uses of sensitive information by the users. Now, there is also a very important question, what is sensitive information? So, when you talk about the sensitive information, it is important to understand the classification of, you see, privacy, private information, information, and sensitive information. Okay, so here we see that when you talk about the private information is basically not classified. Huh. These are not classified information. But when you talk about the sensitive information are to be classified information. And why we did not have a privacy law that too in place, although we have Digital Personal Data Protection Act now. So earlier we also have that provision in the cyber law to deal with the privacy of the individual, but that was not implemented properly. But in 2018, we have Personal Data Protection Bill that was passed, and that became an act, that was Digital Personal Data Protection Act. In 2013, that became an act, and that has provided a protection over the data which are used across the internet. But here they also said that the data which could be protected under the act are supposed to be digital only. So it is not applicable to offline world. It is only applicable to online space, cyberspace. And when you talk about the cyberspace is also involve you see the computer network, computer hardware, software, tools, mobile phone, a device, the information and communication device that you have used. So it involves many numbers of tools. Huh. So here we also see that why we could not so far executing like privacy law. There is a reason also that we did not have a legal framework for privacy, and on the basis of which we can actually draw a law. So after the verdict of the Supreme Court, we get to see there is a framework placed under which we could also claim for privacy. So privacy was also inherent in right to liberty, no doubt. But you say right to liberty is also a bit Western concept when we talk about, and many a time it is also said we have a Indian version of human rights. We talk about right to life, right to dwelling houses, and also right over our body. But at the same time, our rights are mostly collective right. We believe mostly in collective right, modern rights. But human rights concept originated in a West, actually. But we also have a link to human right concept, so it is not unknown to us, about which we have already discussed. No, so we see that although we have that privacy framework now, but we did not classify the information properly, whether this very information are sensitive and this very information are private, and which information are to be sensitive and which information are to be private. Then we did not have any kind of framework to determine the cross-border functionality, cross-border flow of the data. We did not have any law that will determine the cross-border flow of data, and hence it is also very, very difficult to put in place a privacy law and data protection law. But you see, when we talk about the e-commerce and all, everything is governed by IT Act and cyber law. But the jurisdiction of one country is also a matter, because we see that in case of cyberspace there is no specific jurisdiction. So when we talk about the legal jurisdictions, and it will be executed to which boundary is also a question. So there are certain lacuna to come up with a privacy law in Indian context. Because of this very problem, we cannot even consider for a privacy protection law. Now you see that we have discussed about children's privacy online. That is also one issue nowadays, because whenever we talk about privacy of adult privacy of human being, we also try to bring in the children's privacy. And that issue actually came up from very negative revelation of a mother about a problem of her child, and that too in US. So the child is suffering from frustrated related issue, some frustration related issue, which is also being disclosed online. And you see, after that, mother got lot of support too from the online community. But at the same time, that privacy issue of that children, that is has that private life of that children has been disclosed, in the sense that his health issues is being discussed openly, although got the support. And then it might also lead to a negative repercussion on the children, and that was very prominent. And from that, this issue all of like parenting has come. Now this is also very debatable issue with parenting, and in Indian context, we do not have any kind of law as such. And the social media has also give us that identity. At the same time, it is an extension of our life, extension of our day-to-day engagement. So we usually engage with social media for our personal well-being, right? And even for sociability. And there are also different needs which usually an online media, or you see that social media gratify. So that children privacy online usually comes so when the information is shared by the parents, whether parents should take consent from the children or not. Now this is actually an issue, because children cannot give informed consent because they are not matured by faculty. So informed consent cannot be given by the children. So if you reveal any information related to health, now health is a sensitive information, health related information is sensitive information. And if you are revealing the sensitive information related to health, so definitely it will lead to negative repercussion on the children. Okay. So here we also see that there is a due diligence guideline that require intermediaries to notify users not to update, transmit, and store any information that is pedophilic or harm minors in any way. So you talk about this intermediaries. Basically, these are the third parties, and third parties get the information from Google even. We also see from those services which we usually use on day-to-day basis, right? And those intermediaries are uh, being told that they need to notify user not to update, transmit, and store any information that is pedophilic and harm minors in any way. Okay. So further, the intermediary is also required to inform the police about such information and preserve the record for 90 days. So it is mentioned in the Indian IT Act. Okay, and in 66 of IT Act 66E has also been inserted into the IT Act, which penalizes the capturing, publishing, and transmission of images of the private area of any person without their consent under circumstances violating the privacy of the person. So that is also another important issue. Casting couch is happening in the media. So they are also capturing the moment, private, intimate moment. So that is highly debatable at the same time because they intruded into the private life of the people. That how media has also intruded into the private life of the people at times. So IT Act has basically it is meant for using this online tools, online camera, and capturing the private moment. And also there is a reason for electronic voyeurism. We talk about the electronic voyeurism. Electronic voyeurism is there, and even children could also be subject to electronic voyeurism, and that might lead to bring harm to them and other subject to any pedophilic activities. So, Section 66C make an offense to fraudulently and dishonestly make use of electronic signature, password, and other unique identification feature of any person. And Section 66D makes it an offense to cheat by personation by means of any communication device or computer resource. So, where when you use to find this impersonation, this is basically a phishing attack. This might also happen to anyone. You also see that cheating by impersonating yourself. So a person can impersonating your identity, masquerading himself as you and take all the login credentials. And a site can also masquerade itself as another site. A site can masquerade itself as a like that other site can also take the login credentials from the data subject from the users and can also harm the privacy of the individual. Huh. And this is basically known as phishing attack, about which we have a certain clause. And also you see message which grossly offensive has also minaking character, and sometimes this is also related to you see some of the offensive messages. So that also harm the privacy of the people because via phishing attack they could also target people. They could also go for cyber stalking. That is another variety of crime. So there are so many varieties of crime, and which will actually intrude the private life of the individual. So privacy of that person. So the person will not be secluded enough because they are also subject to these varieties of crime. Cyber stalking can be possible, phishing attack, logging credentials have been taken, and also disturb that person, taking the phone numbers and also giving him her call at odd times. Okay, and also you see some offensive, grossly offensive messages being sent, and also hurt that private space of that person. At the same time, false information for the cause of annoyance, inconvenience, danger, insult, criminal intimidation, enemy, hatred, it. This will also, you see, intrude the privacy of that person. So these very issues are related to the privacy. So any issues related to cybercrime are also relatable to right to privacy. And then we actually talk about the provision of IT Act. Um, and protection against the violation of the privacy. And what do you mean by intrusion of computer and mobile devices? So intrusion of computer and mobile devices, that means access to. So we talk about the hacking also, that bypassing the source code and also software, that unauthorized access is possible through which. And then we talk about the accessing, downloading, copying, and extraction of this data and extract any data. That is also another you say intrusion of privacy. Then intrusion of computer contamination through virus, that is also another intrusion of computer and mobile device. Disruption, denial of access, facilitating access by an unauthorized person is also related to you see intrusion to privacy. Stealing, concealing, destroying, altering source code with an intention is also related to intrusion of privacy. Then you see the reflection upon this is the reflection upon Google privacy policy. So all of you actually know about how Google take information from us, and basically there are certain things that you create and provide to us. Google said that there are certain things that we create and provide to them. Okay, so and type of information that Google collect as you use our service, and purpose of collecting the service and the benefit they take from it. So you see that when you use a Google browser, so there is a unique identifier which will actually take all the information from us about the setting of the device that you have used, the mobile network that you have used, the operating system that you have used, as well as the applications that you have used. So most of the informations have already been taken by the Google because we are using that particular service. Apart from that, we also see in My Activity, we can see in Google there is an option called My Activity. So you get to see the keyword that we have searched, the videos that you have watched, right? And also about the location which we have visited, about which also information is being shared by the Google, and nearby information about the nearby tools and technologies, suppose mobile tower nearby us, any Wi-Fi enabled device nearby us, and also about yeah, the IP address are also being extracted by the Google. So once you get the service, once you use the service, you are also susceptible to give the information, and the kind of information they are collecting are sensitive. Now you see, these are not personal information. We are talking about personal and private information. We might also personalize information which are supposed to be public. We might say that this is our personal information on the basis of our own choice. Okay. But when you talk about sensitive information like your name is public, but your address, your date of birth is a sensitive personal information, and about your residential details, okay, are also personal information, and these information are now considered sensitive. Your password details are always saved in Google, so very sensitive information. Your credit card details are saved, credit payment details are saved. These are all sensitive information which are being stored in the Google. So each time you use a service, you are also subject to give your personal information to the Google. You are susceptible to privacy violation. Okay. So you see the type of information they collect. They mention that what type of information we will collect, but they have also said that without our consent, they are not going to share those information with subsidiary, that third party, as well as intermediary or any other subsidiary services. So purpose of collecting the services and benefit they take from it. So Google also mentioned about why they are collecting. They're collecting um, those information. They call it as a service. They're collecting those information from us in order to improve their service. They said that to give us protection, to detect even the fraud, to detect the malware, virus, etc. To give a very enriching experience, they usually provide us those services, and also to collect the information from us. They collect information to detect the fraud, to detect any malware and etc. And virus, and also give us very improved enriching services and benefit which we can take from it. Then we have already told you about data automation. It is there by a lot of technologies are usually go for data automation. Data automation is executed by those technologies. Like you have that Jaiku, Last.fm. They usually what they do, they acquire data from us. They analyze those data. And they implement the data, then they disclose the data. They acquire information about our location, and without even taking our consent at times, and without having user control, they take certain data. So some data are also being given or even shared without our consent, although they said that we usually take your consent while taking this data. Okay, and then they analyze this data as per their marketing needs, and they made it available online, and those data can also be disclosed at the same time. You see, most of the when you listen to a song, the information about that song is also available for everyone, and especially in Last.fm. And now in many online services in Spotify, those information are being disclosed. Huh. So these are also connected nowadays. Why AI technology is there? AI technology connect this information, so AI algorithm, and it has also created a it actually created a blot on the privacy when you talk about this AI. Hmm. So we talk about now Ministry of Information and Technology published a draft rule under Section 43A in order to define sensitive personal information and to prescribe reasonable security practices that body corporate must observe in relation to information they hold. Now you see, when you talk about the sensitive personal information, so we have a section 43A that defines that sensitive personal information are basically the physical and physiological information, our mental health related information, our health record. Then password is our sensitive information, our credit details and financial information. So like that way they have classified that sensitive information. In terms of health, we have also different varieties of sensitive information, right from the bills, pharmaceutical bills and the test result, diagnosed any kind of diagnostic results, and then also you talk about you see that dental record, okay, and uh, so these all are encompassing as sensitive information. Then you have right to, after this privacy, we see we move to right to information. So this is also relatable, quite relatable, but we have discussed about the privacy thoroughly, and privacy is important to understand the surveillance of the government, let me tell you. And when you understand the surveillance has been um, executed in a fair legal framework, executed through a fair legal framework, as we have some national principle of privacy. Uh, but at the same time, when you talk about the private bodies like MyGeo, and there are also other bodies, they usually take some subsidiary information from us, apart from the very basic information for which they provide us that service. You know, suppose you are also getting my Geo services for basically the voice call, but they will also take the information related to your audio details and your information about your voice, information about the location. Okay, so some of the subsidiary informations are usually being submitted when you use one particular service. Okay, and when you talk about the personal data protection bill, now it has tried to give protection to the digital footprint of the individuals. No, this personal data protection bill, that is basically digital personal data protection bill, in contrast to GDPR, that is also General Data Protection Regulation, which was prevailed, which has been prevailed in European Union. In international perspective, the general personal data protection regulation, that is GDPR, General Data Protection Regulation, GDPR, is basically both for offline and online purpose. But when you talk about our Indian Act, Digital Personal Data Protection Act, which was passed in 2023, that is actually meant for safeguarding the digital footprint related to privacy and this data. Then we have right to information. When you talk about the information, it's a very important right to information, right to free uh, praise, right to expression, right to opinion, and right to information is basically comprehended as right to seek, right to impart information, right to seek, receive, and impart information. And when you talk about the freedom of expression now, that is also quite relatable to right to information. First, this is very important for journalists, right to hold information. And when you actually go for in-depth reporting, right to information will definitely very important. And Then you see, this is basically replaces the erstwhile Freedom of Information Act in 2002, and we have a HD Shori draft that was the basis of Freedom of Information Bill, and which eventually became law under Freedom of Information Act. So Government of India has also created a committee under the chairmanship of Dr. HD Suri, and they have drafted a bill, that is Freedom of Information Bill, which became act in 2002, and that act was replaced by Right to Information Act in 2004. In Right to Information Act, I have done mention the year in 2004. So this act actually applies to all the state and union territories except Jammu and Kashmir. Under the provision of this act, you see, any citizen can request information to a public authority which is instituted by the government in each state on any government information, information about any department, information about government certified samples, and any kind of record logbooks, and also if there is a delay in information, then also they are supposed to give uh, information about why there is a delay, okay, and also justification about why there is a delay. So you see, this act actually requires public authority to computerize the information. Now it will provide a easy recourse to citizens to get this information, and hence we actually see that actually requires public authority to computerize the information for easy dissemination. And at the same time it is trying to break the wall of secrecy of the government and provide the unclassified information that is beyond the official secret act. There are certain of information, unclassified information about any developments that whole government are doing, and as government is also accountable to the citizens, any unclassified information is to be given to the citizen, okay. And then we also see, when you talk about freedom of expression, because right to information is also very equivalent, very important to understand freedom of expression at the same time, I'll discuss it about later. So we talk about the role of public information officer, because we are simply seamlessly moving through the slide. So the here you see that as part of RTI applications, we also have role of public information officer and assistant public information officer, and role of Central Information Commission. This public information officer is there, and to help him out in terms of get the complaints and the request, we also have an assistant public information officer, and there is also a Central Information Commission who will take the complaint if there is no public information officer available in a state. So we have a Central Information Commission. They will take the complaint from the person and from the concerned person who is trying to put up an RTI but unable to do it just because of non-availability of public information officer. So information officer is PIO is basically recruited by the government in for each state. And then what is the fee? Fee is a very nominal fee. So if you actually seek for any information, first hour is basically, you see, free hour. But each subsequent hour of searching the information will charge five rupees. And when you actually put up that applications, you are also supposed to pay 10 rupees. And if you belong to this BPL category, then you need to put up proof that claim that you are from BPL category. And then duration of receiving information, it is also mentioned that within 30 days you will receive the information. Okay, and it is very relevant for RTI. That is also for media personnel, it is very relevant. I'll be telling you about this. But apart from this, this is very important, that the kind of information which we can procure through ITI. you actually see that information means any material in any form, including the record, document, memes, email, opinions, advices, press releases, circulations, order, logbooks, contract, report, papers, samples, etc. etc. You see, so we can get information, receive information on these variety forms. Okay, and following is exempt from disclosure under Section 8 of the Act. So we see that there are certain information which are also exempted from disclosure, as I have already discussed about those clauses. So certain information are exempted from disclosure if it harms the sovereignty and integrity of India. Then it will also, you see, hurt the security, strategic, scientific, and economic interest of the state. So any information that will actually hurt the strategic, scientific, and economic interest of the state is not supposed to be disclosed. And information which has been expressly forbidden. Some information are forbidden by the court of law, and that could also lead to contempt of court, will also not to be disclosed. Then we talk about certain information which are not to be disclosed, which might also breach the privilege of the parliament. Okay, those information are not to be disclosed. Then there are also certain information like commercial confidence, trade secret are not supposed to be disclosed, because that will also hurt the competitive status, competitive position of the third party. Then there are certain information, you see, there are which are not to be disclosed, um, uh, like you see are basically of you see private nature, nothing to do with public activity, uh, are not to be disclosed. Okay. Uh, then we see the relevance of RTA for media personnel. So we will be discussing about it, and how relevant it is. When you talk about this investigative journalism, we talk about the role of media uh, to give in-depth coverage of the issues, and also media has a role in information dissemination. When the media has a role to go in depth of any issues, then we talk about the relevance of RTI, Right to Information Act. Yeah. And also make a Right to Information Act will make government accountable at the same time. And for media personnel, how to go about it. So I'll also have a short exercise about regarding this. So I'll let you write, and not related to RTI, but when we will discuss about how to write, then you will get to learn more about it. Okay. So I'm ending my presentation here today. So this is all. If you have any issues or any questions, so you can come forward. Yeah.
First of all, good morning.
Yeah.
So there I have been observed as we are adult, still some of the information, some of the laws, we are not aware about that, right? So in terms of the kids or children, they are, for them it is more severe, I feel, because as we are mature, somehow we understand this information we should not be shared, which is very sensitive. It may be harm to other person, or it may be harm to some community. It may be harm to entire state or entire country for our in terms of like integrity, nationality, this thing. So it is very important to disseminate those information to our kids, to our students, whoever uh, near of us. I think so. This is very important. So some of the questions I have, not questions, it is queries. Like electronic signature or photos or images, which is personal, very secret or very security purpose.
Mhm.
That sometimes the third party or sometimes those private companies they collect.
They collect
Yes.
information.
So
Private
there is a law. There is a law. There is a framework.
Yeah.
Yeah, we
Cyber
know
law is
about.
there.
Yes,
Yeah.
ma'am,
Cyber
yes,
law
ma'am.
is there
Yes,
to
you
deal
have-
with the
yes.
electronic signature.
Sometimes there might be someone who, for the personal benefit or to take action against those person. Maybe might be there might be. So now those person already work in that institution and he has a against of those person.
Mhm.
So in this situation, although there is a law, so if it is the person is work in the law in the government bodies, maybe
Mhm.
not in the private body.
Mhm.
So if or they are trying to do something against of those,
Oh,
how
it can
it,
bring harm.
yes,
Okay, you are
yes, ma'am.
saying that whenever there is, you're talking about the electronic signature and all, no? It is
Yes.
also wiretapping and all.
Other information, so like banking, financial aspect.
Yeah.
those things.
So you said that who will be actually responsible, whether the person concerned who
Yes,
is
ma'am.
taking the information
Yes.
from as he's working in somewhere else, then organization, he represent that organization. At times you see some organization, when you work in an organization, that organization usually had a policy to take our personal information. So we are supposed to submit the personal information, so which are to be in safe custody in that organization. But if one organization is collecting information from another organization or about a person working in another organization, and that too in an unauthorized way, without getting any consent from his organization or from the data subject, from the person from which he has collecting the information, then that is considered a breach of privacy. Okay, but when we talk about our employees, so employers usually take some of the personal information. But regarding the interception and wiretapping, not everybody can do. Now you see, hacking is a different kind of crime, and now hackers are available. You see, like black hackers, white hackers are available, and even a common citizen can also hack your phone call, your mobile devices, your computer, and can break the source code and bypass the source code, take the information from your computer resources. No. And when you talk about the organization, in organization we usually have ethical hackers to even identify those black hackers. Okay, and organization usually cannot wiretap unless and until they get the permission, and that is also permission from the home ministry to wiretap a call. Okay, and also to intercept a call. So that interception and wiretapping is possible. As I have already told you, direction regarding this could be issued by home minister only, but at institutional level, at confidential level, if something is happening and we are unaware, that could be mitigated via the act. Okay, because whatever we are submitting, that is also on our consent basis. So we give consent to use that information. We are submitting this information to these organizations. You are also collecting all our data regarding our family, regarding our children, regarding my well-being, regarding my personality. You have collected the information. Now, while using that information, whether it is for our benefit or their benefit, I need to know, because I have every right to know how this information are supposed to be used. Okay, so that is dealt by that data protection bill, digital data protection bill, and also by cyber law. But many a time privacy is an issue which is not known to many. And like every now and then our privacy is violated, because computer becomes a resources easily susceptible to get corrupted and also disruption and interfered. So when you talk about these computer resources, and when we are open to network, no, then you never know that it's time information which are being circulated will be interrupted or interfered. So it will be taken away by someone else because you do not have control, because now that information has been circulated in the network. Huh. But if you were using an like that what a connection, a network from an organization, so definitely you're giving certain information to organization, but they are also liable to give protection to that information, not to deter the services, the progress of the services, also easy availability of the services or easy consumption of the services. Okay, so that is important.
Thank you, ma'am.
Yeah.
Ma'am, I have another query.
Yeah.
Many person they have been victimized. Like some messages came in their mobile phone. So you pay this much amount, you will get this.
These are
Card.
fraud. These are fraudulent
Yeah.
activities that
Yes.
also hamper our privacy. That messages hampers our privacy. That is privacy means we want to seclude it from the rest in the sense, you see. So in a way, so our space has been interfered. Our personal space, I told you that personal space, that physical space as well as our mental space has been intruded by those messages. So you can either block it or don't disturb. That DND is always there, that features is there, you can go for it.
Is there any tracking to or their digital footprint to tracing them from the government, because they have without knowing or somewhere unaware they send blindly to money to them. So because of their greedy, they also want to get more money. So sometimes they are become victimized. Sometimes they send by video calling like through WhatsApp. I don't know WhatsApp through they can to trace or not. I don't know. But sometimes they call
Yeah.
through videos like
Yeah.
that.
This is also part of telemarketing. This is part of that behavioral advertising.
Yeah.
Now we are susceptible to it. So everybody is used to that micro targeting as our data is already in the cloud. So cloud computing today is like these days are days of cloud computing. So all our personal data are already stored in the cloud. No, so we don't even think to store it because it doesn't require active direct management. We don't have to actively involve in managing the data. So we can store the data in the cloud. Okay. Now you see, when data are stored in the cloud, these are susceptible to be violated. So we also know somebody can take away, and even the service that we are using from a browser and from applications. So you use the service, and they do have terms and conditions, but they will take the personal information, because without taking this personal information, they will not provide you the service. But yeah, there is a provision of opt out, as I have already told you in the national principle, in where I told you in, okay, there is some national principle here. You actually see the choice and the consent. In choice, you can actually opt in and opt out, giving the information. There is also a form at times when you go visit a site, that form will come and pop up and ask about your information, about the product you likely to buy, likely to purchase, and you usually give the information, and then you get call from that advertisers or from that company to buy that product. But if you opt out not to do, so definitely that is your choice, no? So, although you have given consent, but if you opt in, you have given consent, but you have a choice to opt out even. So, I'm not going to fill up this form, okay, because I have come here to read some information. But at the same time, when you come digital, and when you visit a website, you also leave a digital trail, and that trail can also be used by advertisers. The kind of content that you have, yeah, you have reached, you have read out, you have used. So that is also one aspect of it. And you see, in network we usually have that wall garden syndrome, There are certain sites which are always placed in a favorable place, and there are certain sites which are at a disadvantaged place. So there is an asymmetry in the network. Although network is a very anachronistic the you say space, the network, this is free for all, and this is not to be regulated by anyone. But you see, there are certain sites, they usually have a very favorable status, and there are certain sites they usually have a disadvantaged status, and that is based on the affluence and money of that site, you know. There are some ISP, internet service provider, they will always give a favored status to media conglomerate some sites, and they can get better visibility in online. Although there is a mechanism called search engine optimization, through which we can provide keyword and also ranking could be index through even that crawler. But yeah, apart from search engine optimization, this whole network is also divided into favored and you say unfavored zone. So government at times put in place numerous surveillance technologies, you know. As I have told you, in China, there is a surveillance regime. They came up with internet that cartoons that navigated through all the web pages. So each time a user visits a web pages, that internet cartoon will navigate through the web pages. Okay, so that mechanism is there. And this is not basically to you say answer the question of the user, although they have meant that internet cartoons are there to answer the queries of the users about various laws. But these internet cartoons usually intimidate the users not to engage in any harmful behavior, or also use any sensitive information which is deemed sensitive by the government. And then now we also see that we talk about this IT cell and all. And this very IT cell is already there, created in China during that 2006 in Nanjing University. So this is also a collaborative project of the students. So they procure some fund, and they also recruit one to teach a proper line of behavior online. Okay, and that same practice has been adopted by Indian government, also by ITSEC. Now they try to that execute a proper line of behavior, but how far it is fair, that is a question. Okay, so like that way, there are different surveillance technique which are in place in terms of even you say internet cafe. So the number of sites which are being visited, IP address of those internet cafe which are being used, telephone numbers are supposed to be put in, and telephone number from which that internet is being accessed are also to be provided by the government. The number of internet cafe which are also there in one locality is to be registered. In that way also government has already provided a surveillance. So all the informations are being located, so classified in that way, and they're trying to understand how we are using this media and internet technology. Okay, so this is basically internet specific lecture. So when you talk about the privacy, but privacy has a bigger dimension, and when you talk about the general data protection regulation, that is actually applicable to European countries, not in India. But we do have a personal data protection bill, that is a digital personal data protection bill to protect the that digital signature, electronic signatures, then digital you say data and all. So that is one thing. Anything else?